Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
All right, this is State of Michigan versus Deontay Jackson, case 24056850001. Today is the date set for a bond redetermination hearing. Appearances, please.
Thank you, Judge. Steve Vincent for the people.
Oh, Mr. Reagan, you're on mute, maybe. Or he might be on purpose.
On behalf of Mr. Jackson.
All right, Mr. Jackson, sir, could you state your name for the record, please?
Yes, it would be Deontay Jackson.
All right, thank you, Mr. Jackson. Today is the date set for a bond redetermination hearing. Bond is said intentionally unaffordable. Mr. Reagan asked the bond.
As to bond, Your Honor, my client has a bond of $1 million. Tether house arrest. Judge, he's 24, no prior criminal history. I'm sorry. Yeah, no prior criminal convictions to my knowledge. He has a pending trespass matter, I believe, Judge. Nothing assaultive. You know, Judge, and sometimes we talk about really being negligent and really doing stuff that's just kind of out the box a little bit. And I think the police even asked Mr. Jackson, you know, what happened? Were you smoking? And I think he may have even made a statement. I don't know what the validity of the statement is that, you know, hey, according to the report, says I wouldn't do anything intentionally. Maybe it was accidental. You know, he said he was smoking in the room and outside the room prior to leaving. He was talking on the phone and smoking and maybe being very, very, very careless. I don't know, Judge. The facts will come out. Obviously, I'm asking the court for a reduction of bond. I think the bond is excessive, Judge. No, again, no convictions. And, you know, obviously, he won't go back. I understand there was a lot of damage that was caused. I don't want this to be a situation where if it was an accident, Judge, that there is a punishment, you know, in terms of bond based on because of the amount of damages. Obviously, you know, luckily, nobody was hurt. So, you know, I'm asking the court for a reduction in bond and whatever other conditions the court wishes to impose. I just think that, you know, this was unfortunate. And I think that the facts will come out later as this case matriculates in the process.
All right, Mr. Vincent.
Judge, defense is asking for Your Honor to lower the bond. Even though it's $1 million, we're asking you to increase it. 65 out of the 73 rooms in this motel were occupied. We also have allegedly surveillance that ends up showing this defendant opening the room that he allegedly set fire to, smoke coming out of that room, knowing that there was some type of fire that was going on in that room, and then this defendant proceeding to walk away from it, get in a car, and leave. The investigation showed that this fire was incendiary in its nature. I don't have to explain to Your Honor what incendiary means. With the video, Judge, with the fact that just a substantial amount of life could have been lost here. I know defense counsel is talking about negligence or accidental. It's pretty clear just based on the allegations in the video that it wasn't either. So respectfully, Judge, we do feel as though this defendant's a danger, and we're going to be asking you to at least continue, if not increase the bond.
Judge, don't go by the video. We don't know what the video looks like. We don't know what's on the video. We don't know how it can be interpreted. And I'm just saying it's early on. That video, Judge, I have seen the video. I don't know what it looks like. I understand Mr. Vincent says there's a video based on his report, but you know, Judge, we haven't looked through the video to determine what the video actually shows.
All right, I've had a chance to review the investigator's report. And this is a close one. I would note that, and Mr. Vincent taking your argument serious, that there are a number of individuals in this motel. This created a highly, highly dangerous situation. If this fire were to spread with that amount of folks in this place occupied, then that is, that would have been a, something I don't want to, bring into existence. I also have an individual with no prior record, nothing that will indicate anything of the sort. The allegations as read, they indicate, the description of the video indicates that person comes out of the room to smoke, goes back into the room, smoke comes from the room, and that individual leaves the location in a lift. That's all I have as far as the circumstances of what's going on here. I later have there's some sort of interrogation with the individual. That person indicates that they would never say anything intentional. Now, these are allegations at this point. It's something that has to be considered. But I also have the obligation to keep the community safe and make sure that no one is harmed while this matter is pending. $1 million is essentially a remand, and I understand why that bond was set in an intentionally unaffordable bond where the defendant would never be out prior to this matter being resolved one way or another. That being said, I do believe that there is convincing evidence that there is a high danger to the public. If these allegations are, and they're just allegations now, but if this is a situation where an individual is setting a fire on purpose in such a crowded area, then that leads me to believe that something is, I don't believe that a non-cash bond can stop that. If there is something else going on, and we would have we'll have a clearer picture when the defendant gets a chance to have an attorney and talk about these issues. That's going to possibly resolve itself. I am going to lower the bond, but the bond's going to be lowered to something intentionally unaffordable. I'm going to set this at 100,000, 10% with the GPS tether house arrest to a medical facility or a family member's home. Mr. Reagan, do you have anything further?
Oh, thank you, Your Honor, very much.
Mr. Vincent?
Just the fact that in addition to what Your Honor just relied on, there was that investigation where the conclusion was that this was incendiary, meaning it was deliberate and or intentional.
I understand.
Thank you, Judge.
All right, thank you. All right, you're all set, Jackson. 100,000, 10%. Can you call, is that Division 2 where Jackson was at? Or the last person? Bring that person back. Wherever that person was.
Division 2 don't have no phone, so
Or wherever they were. If not, I'm gonna do it without her.
you want to change something?
Yeah, I'm gonna change something. I think I am. We'll see. Mr. Reagan, I gotta go back on the record on that last person.
I'm sorry, Judge, what'd you say? I apologize.
I gotta go back on that last person on the arson case.
What happened, Judge?
Don't worry about it. He just has to go back to it.
I dipped out in the breakout room for 1 second and then we got it. Oh, what happened? What I missed?
I misread the investigator's report.
That's not like you, Judge. You could read it.
I know. Is everybody else, the folks not gonna be available?
Alvarado.
You said Alvarado, Carter, McCarver.
You can wave everybody, Your Honor.
What's that?
Wave everybody.
Well, you said
McCarver,
he's got another case too.
he's got another.
Like he's got an arraignment somewhere else today.
Well, we gotta, I don't want to put it over till Monday, Judge, so I you know, 'cause I know Thursday.
No, we'll hear him because he was supposed to be here yesterday, and I think we got that wrong.
Yeah. So
But
whatever.
we tried to get him, so yeah, I hear it today.
Okay.
All right, let me just start calling these folks, and if we get Jackson back, then I'll hear Jackson again. If not,
A few moments later.
all right, back on the record in the state of Michigan versus Deontay Jackson, case 24056850001. I have to recall this case, Mr. Jackson, and I don't like doing this because I have to show that I messed up. I've had a chance to reread the investigator's report, and it's changing my calculus on this bond, at least according to the investigator's report. What's on video is that it looks like there's a fire coming from the room, that you come back to look at the fire and then come back outside. That changes my understanding of what happened. Mr. Jackson, I'm gonna do this. I'm gonna let you talk to your attorney before I go forward, because I know you wanted to say something and I cut you off earlier, but I think you need to talk to your attorney before I reevaluate this and make a ruling.
Okay, you can go ahead.
All right, 1 second. All right, back on the record in the Jackson matter. Mr. Reagan, and this is a little unorthodox. Based on what I said earlier, do you have an argument as to bond?
I do, Judge, and you know, I always understand that it's two sides to every story. I know the court does. The court's been doing this for so long, Judge, and understands it. And I talked to my client, you know, and it makes a lot of sense, Judge. And I don't think that the video will show everything. This is a very small room, and it's a smoking room. So there's a lot of smoking going on in the room, and it causes a lot of smoke. And I think what my client was trying to do was open the door, get some of the smoke out. But there are other things, Judge, that are going to come out. I don't think, based on what I know at all, he was trying to light a room on fire, trying to, or even thought the room was on fire when he left in the lift. But it's going to all come out, Judge, and obviously we can't argue it now. But I think once his side comes out fully, that, you know, and once you get information from the manager at the hotel or some other individual that can validate what he's saying, I think, you know, because we get one side of it in the investigation report, we get one side of what the police say, but you know, it'll be more, Judge. I think that once the full story comes out, it's not what it seems to be, according to my client, at all.
All right. And I would note these are allegations, but I do believe, based on at least from what I've read, and I have not seen a video, there is a likelihood that this created such a highly dangerous situation that I can't take that chance. Bond is going to remain at $1 million.
Thank you, Judge.
Cash while this is pending. There's going to be more information that comes out when when the defendant has an attorney and we get to the preliminary exam. But at this time, based on the allegations, based on what I have in front of me, I think this is the only way to ensure that community is safe pending case. That concludes the hearing.
Thank you, Judge.
All right, this is State of Michigan versus Sheldon McCarver, case 24056810001 and 24044584001. Today is the date set for bond redetermination hearings. Appearances, please.
Thank you, Judge. And thank you, Judge. Steve Vincent for the people, P 71917.
Working on behalf of Mr. McCarver, Your Honor, who I would ask to waive his presence.
All right, presence waived on this matter.
Thank you, Judge.
Mr. McCarver is here for two matters. We'll start with case 24056810001, which is this is the felony matter, the assault with intent to murder, home invasion. Mr. Reagan asked.
I'm sorry, Judge. I think this is.
Oh, no problem.
Case, Judge. This is a reissued case, I believe. This the A1.
Okay. A1 is a reissue?
That's my understanding,
Okay.
yeah. It was dismissed once and they reissued it. It's my understanding, my client said that he was the one that was actually shot. A report reads, Judge, I think that the complaining witness was trying to, or the defendant was trying to get, I guess, sex from the complaining witness. My client says he was actually the one that was shot. I would note, Judge, he's 32, has a prior drug case in 2015. Does have some pending matters, which he has a personal bond for, Judge. But also has these matters before the court. Your Honor, my client does suffer from bipolar, some schizophrenic situations, but he does have a bullet wound. He did have a bullet wound because he was the one shot, Judge. So, you know, somehow he got kind of turned around, according to my client. I don't know if that's why it, you know, lack of evidence initially was dismissed at exam. I don't know, or discovery. I'm not sure, Judge, but it was reissued again. You know, so I'm asking for a reduction, Judge, and that's 100,000 cash. I'm asking for 100,000 personal, no capious history to my knowledge, Judge. Asking for 100,000 personal with whatever restrictions the court wishes to set for Mr. McCarver.
All right, Mr. Vincent.
Thanks, Judge. And I know Your Honor is always interested in these types of facts regarding the particulars of an individual. Following the dismissal in this matter, and defendant has an ongoing case that defense counsel alluded to. In the next hearing, he failed to appear. He had been going to all of those hearings on that case where he had a personal bond because he was in jail for this case, Judge. But once this case ended up getting dismissed, and the first opportunity at the next hearing on his weapons case, he failed to appear. Actually, it's the reason why he's not here today, because he's getting arraigned on a bench warrant. So contrary to what Mr. Reagan states to Your Honor regarding no capious history, plain as day, we have a capious that is is a reason why the defendant isn't appearing. Now, in this particular, and Judge, one other thing. So while he's also out after the dismissal, he ends up picking up an assault and battery case. So he fails to appear at the hearing and then ends up picking up an assault and battery case. And I believe Your Honor is going to be hearing that case after this. Judge, I'm not going to get into the allegations. You're really good at what you do. You read those things thoroughly. We have, it's basically an accomplice aiding in this matter where somebody was shot. There's plenty of corroborating evidence. And ironically, Judge, one of the other individuals that was involved in this case, his partner in crime, no pun intended, was shot 2 hours later. So that individual is deceased. So respectfully, Judge, there's so much going on here, and a lot of it having to do after the dismissal of this case. Respectfully, we're going to be asking Your Honor just to continue what I believe is 100,000 cash or surety, tether, house arrest. I believe the first bond was actually $1 million. And it went through redetermination. So 100,000 asking you to keep it going.
Judge, so this case was dismissed twice, and my client was never released once it was dismissed.
That's not what you said. You said once.
No, well, I'm looking at my notes now. I'm sorry, I'm correcting myself because sometimes I can be wrong. I'm looking at my notes now. February 2nd, 2024, it was the first dismissal. Discovery was not provided. Judge Giles dismissed the matter. It was reissued on February 5th, 2024. On February 27th, 2024, was the second dismissal in front of Judge Sabri. This time it was for insufficient evidence. That's what my notes say. And then it was reissued again for the third time. And my notes also say he was rearrested, never let him go. He was just rearrested, Judge. So I'm looking at my notes, Judge. You know, and so this is a case. This AWIM was actually, this is the third time it was reissued. The first time was for discovery not being provided. The second time it says insufficient evidence. You know, so I would ask the court to consider that, Judge, in terms of setting bond as well. I don't know how a case comes back with insufficient evidence, but I guess the people have that right, Judge. You know.
Okay.
In Your Honor, but for the fact that he failed to appear on the other case following the last dismissal and then picking up an assault and battery case, I would actually be inclined to agree with Mr. Reagan, but I know Your Honor is also very interested in what happens in that period of time from a dismissal and a reissue. And Your Honor, I just wanted to give you that information.
All right, give me one moment.
Mr. Reagan, I knew about the second reissue. I was just testing.
All right, I've had a chance to review the information as to case 240568101. These are serious allegations. I will note. I'm sorry. You all right, Mr. Reagan?
Is that for us?
All right. These are serious allegations. I will note that there are at least 2 reissues in this matter. For that reason, I'm going to amend the bond to $100,000 cash, strike that $100,000 personal with a GPS tether house arrest while this matter is pending. Mr. McCarver is to be at the house while this case is pending. I don't have any reason why you would have to be outside. So amend the bond $100,000 personal GPS tether house arrest. As to case 240445841. This matter is set for a bond redetermination. Bond is set intentionally unaffordable. Mr. Reagan asked the bond on the assault and battery.
But it's $100 cash. I would just ask the court to make it personal with the house with the same conditions as the other case.
Can't do that. He was pending.
Sorry, Judge. You're right. I'd ask for $1 bond, Judge.
Mr. Vincent Esteban.
Judge, I know Mr. Reagan just talked about $1. I don't think that it's statute anywhere regarding the 7656A where somebody's on a personal bond and picks up another bond speaks to a nominal issuance of a bond. They just speak to issuing of a bond. I would think $1 would be not. Now, Judge, he's out. His AWIM got dismissed. He's on bond for a weapons charge. And then allegedly we have a defendant, just because somebody ended up saying hello to him the wrong way, allegedly chases that individual down and beats them up. Allegedly to the point of unconsciousness, bruising and bleeding and injuries to the finger. And then, Judge, how, you know, on top of the fact that the individual knew him, the defendant drops his ID while he's kicking him, while he's down. And then the complainant ends up recovering the ID, giving it to the police officers. Judge, I'll leave this up to you. I had asked for 10,000. I know it's a misdemeanor. I know how you feel about these things, but there's a lot going on with this ongoing case, now recharged with the AWIM and now an assault and battery. Respectfully, Judge, at the very least, we're just going to ask you to continue.
Well, regardless of how I feel, he's gonna hit the maximum amount of time that I can give him on a conviction before this matter even gets to court.
I
So,
mean,
you know, this
yeah.
is, you know, this is our system. This is what we're due.
right.
Bond, I'm gonna amend the bond of $10, 10% with GPS tether house arrest.
Thank you, Your Honor.
That's a potentially nominal bond that's unaffordable.